next topic, statute of limitations. There is a 4-year statute of limitations in Florida, which is under 95.11 sub 3, paren 3, excuse me, yes, paren 3, paren C, which is very specific, to construction claims. And any action under 95.11 3C, any action found on the design, planning, or construction of an improvement to real property, you get 4 years. And that's regardless whether you have an oral agreement, because here in Florida, as the attorneys here in Florida know, generally speaking, under an oral agreement you have 4 years to sue, and under a written agreement you have 5 years. It's a written instrument, written contract, and you're suing for breach of that contract. You generally have 5 years from the date of the breach. But as we all know, specific governs over general, so the specific provision 95.11 3C that deals with construction is going to apply. So even if you have a written construction contract, you're going to be limited to 4 years to bring your cause of action, and that runs from the later of the date of actual possession by the owner, issuance of the certificate of occupancy, or if the construction is abandoned by the contractor, and obviously you don't have a certificate of occupancy that's issued, so building is not completed, and you have an abandonment, then that can be a triggering event, or completion of the project, or termination of the contract. So if you have a situation where the owner terminates the contractor, it'll be the later of those dates, and you get 4 years. And for condominiums specifically, that runs from the date of turnover, and that is, I've cited a few cases there, and that makes sense because while a condominium is under the control of the developer, obviously the association is not able to bring the claim against the developer, and so it runs from the date of turnover, so you have 4 years. Latent defects under the statute, you have up to 10 years. That's they refer to that as the statute of repose, and I remember way back when I first started practicing civil practice in construction, the statute of repose used to be 15 years. But at some point they shortened that to 10. And really what that means is you've got 4 years from the later of those dates that I talked about. You've got 4 years for a construction claim to bring that. If the defect is latent, and that is, again, it was hidden, could not be discovered by casual observation or reasonable inspection, and it's latent, then you could actually have up to 10 years, past one of those triggering events to bring your cause of action. Now, having said that, and I could devote a whole subject to surety bonds, but we probably won't have time. But if we do have time when I'm done, it's not in your materials, but I can spend a little time talking about surety bond claims. But the statute of repose does not apply to sureties, and that resulted from Federal Insurance Company versus Southwest Florida Retirement, which was a Florida Supreme Court case. I think it's a horrible case. The Supreme Court got it wrong. They actually applied a 5-year limitations period for sureties because they applied the 5-year limitations period applicable to written agreements. A surety bond is a contract. It's a written agreement. And I think I know they did that because they glossed over it in the opinion. They say the parties, I'm going to have to call out. You ever listen to Joe Rose show in the morning for people that are here in Florida? You've been called out. Well, the folks the parties that litigated that case, they conceded for purposes of the appeal that the 5-year limitations period applied. I have no idea why they did that. So anyhow, the court applied the 5-year limitations period for surety bonds. So if you've got a defect claim against a contractor, you can obviously go up to 10 years if it's a latent defect. But if you're going after the contractor's performance bond, it's a 5-year statute of limitations. I don't agree with it. I think clearly 95.11 3C applies because, as we all know, with performance bonds, they incorporate the contract by reference. And so if I can make a claim against my contractor under the statute of repose, why can't I make that same claim against a surety bond? But So says no under federal insurance company. Now, that being said, you certainly could probably purchase extended coverage, but then the cost of the bond more. But in the absence of some endorsement or some rider or some extension of that, you're going to be limited to 5 years in order to go after a performance bond surety for construction defects. And I touched upon this earlier. Statute applies regardless if the action is founded on contract or negligence. Either way, you're going to be limited to the 4 years. And where there's an obvious manifestation of the defect, in other words, when does it become apparent to the building owner? Where there's an obvious manifestation of the defect, the plaintiff's notice of the defect is inferred at the time of manifestation, regardless of knowledge of the exact nature of the defect. And so even though you may not know exactly what's going on, where there's an obvious manifestation that there is a defect, the clock starts ticking then, and that's under the Wisnowski case that I've cited. And here it's very interesting because in that case, small cracks in the foundation were not sufficient to put the purchasers of a house on notice of construction defects in the foundation. Apparently there were small cracks, and the court said, even though you knew there was a defect, there wasn't a manifestation that there was foundation defects. And later, large cracks started to appear in the foundation, settlement occurred, and when that happened, the court said that's when the 4-year period started to run, and the plaintiffs in that case brought their claim within that 4-year window, and the court found that it was timely, notwithstanding the fact that the purchasers were aware that there were some small cracks outside of that 4-year window, but again, they weren't aware specifically that there was a defect in the foundation. Where the manifestation of a defect is not obvious, but could be due to causes other than an actionable defect, notice as a matter of law may not be inferred. Now, and that's the Snyder case I've cited. Now, notice may be, you may be able to show that the plaintiff was on notice outside of the 4-year limitation based on the facts of the case, but notice as a matter of law, and I think that really deals with summary judgment issues, is not going to be inferred where you've got a defect that could be attributable to one cause, but also could be attributable to other causes other than an actionable defect. And I think it's important to be aware that there are different triggering dates for water intrusion cases. I don't know why, but apparently there is a dichotomy of cases. There's the leaky roof cases, and those came out of the Kelly versus School Board case, Florida Supreme Court case, 1983, and basically said where you've got new construction and you've got a roof that's leaking, you may not know exactly where that leak is coming from, but pretty sure it's from defective construction, and the courts there are going to say that the time starts running from the date of that leak. And you may not know why it's leaking, and it may take you years to find out the ultimate cause. Hopefully it doesn't take you that long, but the limitations period is going to start running. So so leaky roofs are really on one side, and then underground pipes is a different triggering date, and that's under Board of Trustees versus Santa Fe. And I think the rationale there is it's obvious. Is obviously you've got underground pipes, and without some sort of destructive testing, you may not know that there's an actionable defect that is coming from the underground pipes, so that you could bring your cause of action timely. And so you typically see that you'll get a longer period of time to bring those claims. In other words, the 4-year period will not start running until a later date if you're dealing with an underground pipe situation. And of course, if there's stucco defects or water intrusion from stucco, that has a different triggering date. And so, anyhow, I wanted you to be aware of that, and I've cited to the cases, so you can certainly take a look at those. Or not. Agreements affecting limitations period. These are, in my personal experience, I've used these. These are very important tools in dealing with defects, because sometimes defects can could run a very long course from the time that they first exist, from the time that an owner discovers them, and then, of course, from the time that the owner has the ability to timely bring a defect lawsuit within 4 years. And I would make a recommendation that you consider using a tolling agreement, because I mean, if you find out about it late in the game and you're up against the statute of limitations deadline, the natural reaction is, I've got to go out and I've got to get a lawyer, I've got to sue, and of course that takes time and money to do that. And if the other side is amenable, I would recommend that you sign a tolling agreement. And there's no magic language, but again, if I've done them, if you want to send me an email, I'd be glad to give you one that I've done before. But you basically, both sides agree that you toll or stop the limitations period from running while the parties further explore the nature of the defects, the causes, and maybe you even work things out before you have to go into expensive litigation. And so I think they are very useful. They are enforceable. And I would highly encourage you to consider using a tolling agreement if you think that it warrants further investigation and discussion with the other side, and you're running up on a statute of limitations deadline. And under those agreements, you can either have it for a specific time period. So expressly, the language can say that the tolling period expires on a date certain, regardless of where you're at in the process of investigating it or trying to settle it. And of course, then the clock starts ticking again. Or it can be for the duration of the agreement. Or, and I've done this in cases, I don't necessarily like to be limited to a specific time period. So I'll put a provision in an agreement that says until one of the parties provides direct notice or express notice to the other side that the tolling period is ended, it'll go on indefinitely. And so therefore, you don't have to feel the pressure of continuing to get what you need done pre-suit before that period expires. And if you're going to do that, I would recommend that you have some reasonable period after, after you give notice. You can't just say, oh, the day after I give notice that, the tolling period is done and your statute of limitations expired. I think you have to provide some reasonable period of time after one side gives notice that, yes, in the next 30 days or so, whatever period you want to come up with, that the tolling period is going to end and the clock's going to start ticking again. Another agreement that can affect limitations period is a standstill agreement. Now, tolling agreements you typically see before a suit is filed. A standstill agreement is going to come into play after a lawsuit is filed, and you're probably asking yourself, well, why would I do a standstill agreement once I've filed a lawsuit? Basically, the statute of limitations is told anyway, and once you've timely filed suit, you don't even have to worry about a statute of limitations defense. Perhaps. Well, what happens if, and I know no one who's watching this has ever been guilty of this, present company excluded, of letting a case sit for too long, and then you get that notice from the court, the FWOP or the DLOP, for want of prosecution or dismissal for lack of prosecution, DLOP, as I like to call it. When you get those notices and the court says, hey, get off your duff and get this case moving, or I'm going to dismiss it for lack of prosecution. If a case gets dismissed because of lack of prosecution, it is a dismissal without prejudice that allows you to refile it. But if you're outside of your limitations period, that dismissal now operates as a dismissal on the merits, because now you're outside of the limitations period. And even though the court order says dismissal without prejudice, that effectively is a dismissal with prejudice, because you're not going to be able to refile that suit, or you can refile it, but you're going to be met with a statute of limitations defense that's going to carry the day. And so a standstill agreement is important because depending on how long you may want to take to investigate a claim, if you have a standstill agreement, both sides can say, you know what, we're going to stand still on this lawsuit. We're going to stop incurring, expensive litigation expenses and discovery, deposition, and we're going to try to further investigate this case informally and come to a resolution. And of course, if you do that, and then hopefully you can avoid a dismissal or let the court know what's going on, or you can even ask the court to stay the lawsuit, which I think would probably be the smartest thing. Court's not necessarily bound by your agreement, so if you do want to have a standstill agreement, I would tell you that the party should probably apply to the court for a stay of the lawsuit, because a case can't be dismissed for lack of prosecution where there's a stay in effect. Now we've got a question from Theodore Wolf. how do you feel about modifying limitations periods by contract before work begins? Do you believe such contract provisions are generally enforceable? Well, Theodore, under Florida law, any contract provision that attempts to shorten a statute of limitations is unenforceable, and that's actually on the slide that we're talking about, which is 95.03. I'm glad you brought that up. If you attempt to shorten a limitations period, Florida statute says no, you can't do that. It's void and unenforceable. And I see it all the time in contracts where someone says, you've got 1 year to sue after this, or, you've got 2 years. And I see that a lot in performance bonds where sureties try to limit the time within which the obligee under the bond, beneficiary, usually it's the owner, can bring a lawsuit, and they try to limit it to 2 years. Again, those are not enforceable under Florida law. Now, I haven't seen where if you want to provide additional time, why the parties couldn't do that, but if you attempt to shorten the time period, then that is unenforceable. So wrapping it up on standstill agreements, again, I think the best course of action is to apply to the court for a stay, and therefore you don't have to worry about a dismissal for lack of prosecution.